The Notice to Known Creditor process. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine State Court Administrative Form PC 578. This form, SCAO for State Court Administrative Order, PC for Probate Court 578, it's a form that's readily obtainable through a Google search, or of course, you can contact my office. We'd be happy to provide you one free of charge. This form is utilized as part of the probate administration to give notice to known creditors. These are creditors that you're aware of as personal representative or should have been aware of. Should have been aware of by monitoring the mail, or you're aware that there may be a debt that exists. So you're giving notice to people that the decedent owed money to. That's the idea here. So whether it's people or businesses, this creditor process gives notice to those known creditors. Now, for creditors that you're unaware of or wouldn't be aware of, you have to go through another process called the Notice to Unknown Creditors. And that's done through publication, and I provided a video and explanation of that State Court Administrative Order form and the process. So understand, you're giving notice to known creditors by giving notice directly to them, and you're giving notice to unknown creditors by publishing in the legal news. By doing this, you're fulfilling your responsibility to give notice to creditors as part of this administrative process. If you fail to do so, you could be held personally liable for failing to give that notice, and it's a breach of your fiduciary duties. So really be careful about understanding the responsibilities related to the creditors. Now, with all of these state court administrative order forms, they are created by virtue of various statutes and court rules. And in the bottom of all of these forms, there are the statutes and court rules that explain why and how to fill out this form. So this floating arrow is covering the particular statutes and court rules. Let's cover them one at a time. 700.3801 identifies the requirement of the personal representative to give notice to creditors, both by publication as well as to a known creditor. And this particular part of the process provides that when you do so, the creditor has a certain amount of time, a finite amount of time, to submit a statement of proof of claim or to file a lawsuit against the estate. If they fail to do that within that time frame, and you as personal representative have fulfilled your responsibilities as personal representative by giving correct notice, then all of the creditors are statutorily barred. So they can't come forward after the fact and say, oops, we forgot to respond to the notice to known creditors, or oops, we didn't respond to the publication notice. So this allows you as personal representative to give notice to the creditors and puts the onus on the creditors to then follow the statutory requirements to file a statement of proof of claim. With these notices to known creditors, you are to provide the notice, and then there's a proof of service to show proof that you gave notice to those known creditors. There are particular court rules that are also related here, which include MCR 5.208B, and that particular court rule provides that when you give notice, whether you're the personal representative or the trustee, you have to do so within that time frame, and by doing so, you are absolving yourself of responsibility as long as you're giving notice to the creditor correctly. The statute also provides that if at the time of the publication, the address of the creditor is unknown or could not be ascertained after diligent inquiry, the name of the creditor needs to be included in the publication notice. But here for the known creditor, these are creditors that you're aware of. You've got their address. Now, one of the complicating factors that occurs is that sometimes a creditor has a servicing agent or maybe a collection agency. We strongly urge you to give notice to both the creditor and the agency to prevent one or the other from coming back and saying you didn't give appropriate notice. So as you're getting bills, as they're coming in the mail, and you're receiving them as personal representative or trustee, you should be keeping those bills together, identifying the information off the address of those particular creditors, and identifying them on the notice to known creditors so you can give them notice. So understand that the bills are coming in, and you have a right as personal representative to simply pay those bills. You can do that. But you could also require them to prove that they're a creditor of the estate by requiring them to go through these steps. So a bill comes in, you send them a notice to known creditor, and the creditor then has to follow the statutory requirement to file a statement and proof of claim correctly to perfect their claim. And then there's an opportunity to disallow that creditor claim, which is, again, another process for another video and another scale form. So let's work our way through this particular form. At the top left corner, you'd identify the county in which the probate is being handled and the file number. If this is being used in a trust context and there is no case or file number, of course, you would just not include that information there, because in trust administrations, many times there is no supervision of the probate court. In the center section, it's pretty intuitive. You'd identify the name of the estate, and then, of course, the correct identification and address for the for the creditor. And in this particular section, you can see that the form was designed so you could trifold it and put it in a clear window envelope, but you don't have to do that. So you'd identify the name and address of that creditor, and then here is the information as personal representative. You're saying that the fiduciary, personal representative or trustee, believes you may be a creditor of the estate, and you would attach the notice to the creditors that's done in PC 57 form, another process that I've identified, which is the publication process. So you identify when you publish, and you provide the copy of that notice as part of this notice to known creditor. Then the center section says that you have 4 months from the date of the publication, or 1 month from when this notice is sent, whichever is later, to present your claim. So it's important, you've got a 4-month window from the publication notice, but if you give a notice to known creditors at the tail end or at the end of that 4 month, then of course you'd have 1 month extended onto it. So we urge you to give these notice to known creditors at the onset when you're publishing, so that that 1 month falls within that larger 4-month window. And again, it tells the creditor that they have to file a statement of proof of claim, which is the scale form PC 579, and has to be done timely. And the claim can be delivered or mailed to the fiduciary, the personal representative or trustee, and you can also file it with the probate court with a $20 filing fee. So again, I'll leave that to the creditors to decide if they want to pay the $20 and submit their creditor claim. But they also have the right to just simply file a lawsuit. Now, there's a lot of confusion here, because some people thought that as a creditor you could enforce your creditor claim by simply filing a petition or a motion with the probate court to compel the payment of the claim. And in fact, the case law and then statute clarified it that it must be a lawsuit, which means it's a complaint that's filed in a court of competent jurisdiction against the estate to sue the estate for purposes of the debt. So a creditor can file a statement of proof of claim, a creditor can file a lawsuit, or a creditor can simply do nothing. The bottom section, pretty intuitive, the name of the fiduciary upon which the claim should be submitted, their information, and then on the left side, the attorney and the date. Now, if you're a creditor, I urge you, send it to the court, send it to the personal representative, send it to the lawyer. The more opportunities to get paid, the better. On the bottom section, the proof of claim section here gives the fiduciary the ability to show that they have proven that they have actually sent out this notice to known creditors. So it's pretty simple. It's either done by mail or personal delivery to the creditor, which usually doesn't happen. But it's signed, and that proof of service then gets filed with the court to show evidence that that creditor was provided with notice of the, was given this notice to known creditors, and that the personal representative is asserting under the penalties of perjury that they've performed that role. So this is the notice to known creditor process here to give notice to a creditor that you're aware of. Please remember, you have to do both to fulfill the statutory requirement, notice to known creditors, and publication for unknown creditors. At the Probate Pro, we're passionate about everything probate. If you have questions about the notice to known creditor process or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.